Welcome, everybody, as y'all are just filtering in. Hopefully you can hear me all right. My name is Matt Whiteley. For those who remember me from previous webinars, part of the team here at the Housing Exchange and REOX. With us today is Sheila Raper, another member of our team here, who I'm sure many of you know. And we're joined today by Robert Sambursky. We're excited to have him here today to speak to us on just navigating legal landmines and just a lot of questions there and a lot of expertise he has to share on liabilities and different challenges in foreclosure that could be really helpful to be aware of. In just a minute here, I'm going to just hand it over to Robert, let him speak. And at the end, as usual, we'll have a Q&A session. So as you have questions, please feel free to post those in the chat. We'll be keeping an eye on those. So if you send it, while you're thinking about it, we're not going to lose sight of it. We'll circle back to those at the end. But of course, if you have them at the end, feel free to share those as well. And people will continue to filter in, and that's all right. I don't want to take more people's time than we need to. So, Robert, if you're ready, I'll hand it over to you.
Absolutely. Thank you, Matt. And thanks, Sheila, for having me here today. I'm going to go ahead and I'm going to share my screen. Matt, did that go through?
Yep, see it.
Okay, perfect. Again, my name is Rob Sambursky. I am with the law firm of Stein, Wiener Roth here in New York. I have been in the foreclosure industry for almost 25 years. I've been with the same firm for that amount of time as well. And I handle the REOs and evictions for the firm. And what I'd like to do here today with you is basically provide you with a practical approach to handling REOs and evictions and navigating some of those legal landmines that Matt referenced. And to give you basically an attorney's perspective on how I work with agents and the servicers and coordinate together to reach the common goal of getting the property vacant, getting it sold, and doing it in a timely manner. Going over some keys to mitigate the delays in the REO process and in the eviction process, and do it in a most efficient manner. Little silly disclaimer, but obviously what I'm saying today is for informational and educational purposes. I'm not giving legal advice. I don't want somebody to go back to their client and say, "Hey, Rob Sambursky said we could lock this guy out. Let's go do it," and then start all sorts of problems. So obviously, I always encourage you to consult with local counsel and make sure that you're doing everything in compliance and following the proper rules and regulations. So I'd like to start with just some foreclosure basics. There are two types of foreclosures: judicial versus non-judicial. Obviously, non-judicial foreclosures are quicker. You're not going through the court system. You're avoiding backlogs, dealing with judges, and it's a much easier process. Here in New York, we're a judicial state, and just to show you, on average, the national average for foreclosure is 762 days. I looked it up in Minnesota. The average is 162 days. That's a non-judicial state. In New York, here it's over 1,900 days. So you're talking about less than a year as compared to over 5 years. Now, the 1,900, that's not the average for my firm. I think we do things a little bit quicker, a little bit more efficiently, but it's an example of how the judicial states are extremely backlogged, and it's a much longer process, and it's a bit more tedious for the investors, and creates more problems, obviously, along the way. Certain states do offer what's called an expedited foreclosure. If you can establish that the property is vacant and abandoned, you do have the opportunity to do what's called an expedited foreclosure. New York has a very expansive statute which allows for that, and in certain circumstances it could save up to 6 months off the foreclosure. You have to follow certain rules. I'll get into that a little bit later on. And some other states I do know offer expedited foreclosures too. One rule that's basically a blanket rule is there's a 120-day waiting period before you can start a foreclosure after a default. So once the loan goes into default, you basically have to wait 4 months before the first legal process can be filed. So, right from the beginning, we're creating a situation where a loan is in default and really not much is being done. Which kind of has a domino effect further down the line. I just wanted to touch on a few market trends, see where we are right now. There is a record number of vacant properties. It's at the highest it's been in several years. As of the third quarter of this year, 1.3% of all homes nationwide are vacant. And out of the 222,000 foreclosures that are pending, about 7,500 of those are characterized as zombie foreclosures. And I'll get into what a zombie property foreclosure is in a few minutes. Foreclosure filings decreased in 2024, but they are on the rise again. They have increased in 2025. And there's, obviously interest rates are higher. Inflation continues to be an issue. It's creating a strain on the housing market and obviously has an impact on the affordability of homes, which has a direct impact, obviously, on what we do. So basically, what is the role of the agent in the REO and in the eviction process as, it relates to what we do as attorneys? So communication is the key. I rely on the agents to provide me with the necessary information so that I do my eviction properly, so that I do my REO sale and prepare my contracts properly. What does that mean for you? Well, the first thing is what I find to be the most advantageous are routine inspections of properties. It's fundamental and very important that the properties are routinely inspected. Have they been, are they occupied? Has the current occupants vacated? Are there property violation issues that might be coming up? It's very important to stay on top of those issues, report anything back to either counsel or the client. And for those occupied properties, it's equally as important to try and make contact with the people who are living there, try and develop a rapport with them, see if a cash for keys can be worked out. Obviously, that's the best outcome for an eviction proceeding is probably next to a voluntary vacate is maybe do a cash for keys and avoid the lengthy eviction process. Here in New York, evictions can take, several years. So obviously we like to think of alternative outcomes, cash for keys, giving them, or relocation assistance as it likes to be called. And I also find it very helpful when working with agents when a property comes into inventory to conduct a FOIL search, Freedom of Information laws, find out what's going on with the property. Are there violations? Is it missing a certificate of occupancy? Is there, zoning issues? Having all of that information right from the beginning is super useful. It's super important. It lets us address things right from the beginning and not later on down the road when, we're going into contract and we find out, hey, wait, we're marketing this property as a two-family, but the certificate of occupancy only says it's a single family. So things like that, that's where the agents can be super helpful in gathering that information and providing it and allowing us to accurately market the properties. So evictions in the foreclosure context. The eviction is obviously, when we're doing it out of a foreclosure, is different than your normal landlord-tenant dispute where a tenant hasn't been paying his rent and you're bringing a non-payment. So the first thing that is really important is to determine who's occupying the property. Is it the former owner? Is it a tenant? Does the tenant have a lease? Because based on whatever their occupancy is, there are different notices that have to be provided. So for example, we have back in 2018, the Protecting Tenants at Foreclosure Act, which is still active, it was made permanent. And that requires that anybody who's occupying the property as a tenant under a lease, under certain other circumstances, is entitled to a 90-day notice. So I can tell you from an attorney, an eviction attorney, there's no worse feeling than getting into court and thinking that you have a non-tenant occupied property and going through the eviction and you're 6 months in, and the tenant shows up one day in court and says, "Hey, wait, I have a lease. I was entitled to this 90-day notice. Now I have to withdraw my eviction, go back, and basically start the eviction over again." So it's really important to identify who's living there, what their status is, what their legal status is. Sometimes they're squatters. I'm going to get into the squatter situation in a few minutes, but it's really important to know who we're dealing with. And it's not always possible. I understand that it's not always possible to make contact with the occupants. Sometimes they're standoffish, sometimes they don't respond. And in those situations, my policy is I err on the side of caution. I'll treat them as a tenant. I'll serve them with the additional notice and make sure that I have all my bases covered. But in those situations where it's possible to make contact and see what's going on with the occupant, see what they're looking for, whether it be cash for keys or they just need a little bit of time to vacate, that's super helpful and beneficial to the client in getting the property vacant as quickly and as efficiently as possible. So squatters has become a huge problem, especially here in New York, and I know in other parts of the country. In New York, squatters previously had what are called squatters' rights. And what that basically means is that if anybody moved into a house with or without the permission of the owner and was there for more than 30 days, they acquired rights. And you couldn't just remove them. You have to go through a whole process. So you still have to go through the process, but New York recently passed what's called the good cause eviction law. And while it's, in my opinion, a terrible law, it did do one good thing, and it excluded a squatter from the definition of a tenant. So squatters now, anybody who's in a property who has entered the property without the permission of the owner does not enjoy the protections that a tenant under a different definition would enjoy. Now, that being said, it's still a civil matter. I have plenty of clients who, call me up and say, "Hey, there's a squatter there. Can we just get him out?" And I say, "No, you still have to follow the eviction process, but they're not going to be able to put up the same defenses that they would previously and allege some type of rights as a tenant." I will share with you crazy story. This is out of Staten Island here in New York City. I don't know if any of you are familiar with it, but we had an eviction that we commenced, and it was occupied by squatters. And in the middle of the eviction, the property burned down. It was completely destroyed. So the squatters left the property. Thought that was okay. We rebuilt the property. It took about 3 years. Had to get the necessary permits, certificates, construction issues, whatever. So 3 years went by. We finished the construction of the property, listed the property for sale, and the squatters who had left 3 years ago moved back in. And the agent went to the property and they saw that someone was in there. And they said, "Well, you're not supposed to be there." So they changed the locks. So these people had the audacity to commence an illegal lockout proceeding against our client and our agent, basically saying that they believed that we were fixing the property up for them so that they can move back in. And this is 3 years later. So that's the kind of nonsense that we deal with. Fortunately, the judge saw through what was going on and dismissed the case, and we got him out and were able to sell the property. But squatters have become a huge problem. There are professional squatters out there, and they look for these properties. They look for these REO signs on properties, and some of them really know how to manipulate the system. So from an agent's perspective, it really requires a lot of due diligence on your side, routine inspections. Are there any signs that, somebody's trying to access the property? Anything that would indicate that needs to be, conveyed to counsel, to the client as quickly as possible so that it can be addressed. I know a lot of states are now passing laws as it relates to the removal of squatters. This is just a list. I won't go through it in detail, but this is a list of states that are or have passed squatter-specific laws, and some states that are currently considering them. I know in New York, where actually there is legislation that has been proposed. It hasn't been passed yet, but it would basically allow an owner, instead of having to commence an eviction, to simply provide an affidavit to the sheriff or marshal, as the case may be, stating, I am the owner. I did not give this person, this occupant, permission to be there. They are a squatter. And with that affidavit alone, the sheriff or marshal would be able to remove them. Obviously, you want to be sure that what you're putting in the affidavit is accurate, but it would certainly save us a lot of time, and I'm hoping that legislation does ultimately pass. Because if it doesn't, then you may be deemed to have done an illegal lockout. Illegal lockouts are not good for our clients. They can carry substantial penalties, both criminal and civil. In New Jersey, an illegal lockout could be punishable by up to 6 months in jail. In New York, civil penalties, you can be penalized and hit with a fine of up to $10,000. Tenants have remedies too if they are illegally locked out. I have this it's not a great story, but whenever a client calls me up and says, hey, look, we went to the property, there's just, some personal property there. Can we just dispose of it? And my first answer is no. And then there's a series of questions that I'm going to ask. Is there any signs that the occupants who were there have definitely vacated? You want to be sure that they have vacated. And what are those signs? Is the mail piling up? Is the grass overgrown? Are the utilities turned off? Speak to some neighbors. Have they confirmed that nobody has accessed this property in quite some time? I can't tell you that just throwing out the furniture and changing the locks without legal process is the right thing to do. But what I can do is I can mitigate the client's potential exposure. I asked, has the agent provided us with an inventory? What's in the property? Is it just a couple of old, couches that are worthless and there's really not much exposure if we throw it away? Or are we talking about, a beautiful dining room set that's worth $5,000 in a fully furnished house? It's more of a business decision that I will give my opinion as to the client's potential exposure by proceeding that way. And I rely a lot on what the agent is going to report back to me and to the client. If it's the day after the foreclosure sale, I would say maybe let's sit on it for a couple of weeks and see what goes on. But there's definitely some due diligence that needs to be done to ensure that it's not an illegal lockout. We had a case here years and years and years ago where we went in, there was really not much there. And it wasn't me, but the owner went in, there was not much there. They cleaned it out. And then the guy comes back and he says, I had a collection of Rolex watches. They're gone. They were there. So I always tell my clients, have the agent inventory everything that's there, even if it's garbage. Inventory, take pictures, videos if you can. Do not allow them the ability to come back and claim that, we removed anything of value, and that increases the exposure to the client. We obviously don't want that. Zombie properties have become an increasing issue in foreclosures. The zombie properties are more prevalent in judicial foreclosure states than I believe, and then in non-judicial. And it's because the judicial foreclosure takes such a long time that in a lot of instances, the borrowers will vacate and just leave the property. And, you have a property that's now sitting for 3, 4, 5 years, completely vacant while we have to navigate the foreclosure process. Like I said, especially in the judicial states, and a lot of localities have enacted laws to address zombie property. So what is a zombie property? A zombie property is essentially a property that is either in foreclosure or in delinquent status and has been vacant, abandoned, and is not being maintained. New York adopted some comprehensive legislation back in 2016, which requires banks to inspect properties within 90 days of a delinquency to secure it and maintain it. You have to register it, and if you don't, banks can be fined up to $500 a day. There's the chance for substantial exposure and liability if they don't properly register and maintain these properties. There are localities here on Long Island in Suffolk County where these inspectors literally drive around all day just looking for these properties, and they hit you with a fine real quick. And it's a huge revenue builder for these localities, these little local governments. And it's super important to be on top of that. I know other states have also adopted similar laws. The only good, I don't want to use the word good thing, but the only benefit, I guess, for a zombie property is it allows for an expedited foreclosure. So if we start a foreclosure and we can determine and establish that the property is a zombie property, then we can do an expedited foreclosure where you can skip certain steps in the foreclosure and obviously get it done a lot quicker. Obviously, the plaintiff has to continue to maintain the property. And even after the foreclosure is completed, there are still requirements to maintain these properties. In New York, we have to get the property, I think, repaired within 90 days and then listed for sale and sold within 180 days. Zombie properties have become a blight on communities. Local governments are stepping up and really enacting laws to try and reduce the number of these properties and keep their neighborhoods in good condition. So it's definitely a huge problem, and it can certainly cause a substantial amount of exposure to the clients if they're not being maintained. I'll discuss very briefly some title issues that come up in foreclosure and REO. The most common thing that I see after a property comes into REO inventory and I'm doing a title is more so a defect in the foreclosure, a misjudgment. Super important to identify those from the beginning and not wait until it goes into contract and then we realize the buyer has ordered title and now we see, oh, there was a misjudgment. Now we have to kind of re-foreclose or negotiate a settlement. Right from the beginning, we try to identify any potential title problems, get those addressed. In the foreclosure realm, the biggest issue that we see here in New York, and I guess lucky for everybody else, it's exclusive to New York, but it's called the Foreclosure Abuse Prevention Act. We call it FAPA. It's a huge problem. It's the big hot topic here in New York. And basically, what FAPA is, it's a piece of legislation that was in response to a court case in which, previously, bank could, discontinue a foreclosure action if they deemed necessary and then restart it and not have to deal with a statute of limitations problem. So the statute of limitations in New York is essentially 6 years to start a foreclosure after a default. What FAPA says is that banks no longer have the discretion to just voluntarily or unilaterally discontinue a foreclosure. They have to ask the court. And it's a complicated statute. There's a lot more to it. I won't bore you with it. But what I will tell you is as a result of the statute, we are constantly being faced with motions by borrowers who are now on their second, third, even fourth foreclosure action and basically saying, hey, wait a minute. There was a foreclosure started 12 years ago. This foreclosure is now barred. you can't start the foreclosure. And at least twice a month, I'm seeing a published decision where a judge is dismissing a foreclosure case with prejudice and basically telling these people, you can now live there without this mortgage. Mortgage is wiped out. It is set aside. It is no longer enforceable. It is a huge problem in New York. There are attorneys out there who are just scouring court cases, looking for these situations where they can challenge the validity of the foreclosure and whether it's barred by the statute of limitations. The constitutionality of the statute is currently being questioned, but as of right now, it has been deemed constitutional. So it's just a constant problem, and banks are taking a huge hit on these. So it's a real problem. Issues that you as agents can assist with. We deal a lot with HOAs, condos, and co-ops. Co-ops are not exclusive to New York, but in New York City, they're very there's a lot of them. There's a lot of co-ops in New York City. Co-ops are a particular problem because co-ops are technically personal property, and co-op boards, the board of managers for a co-op has really unfettered discretion to basically do whatever they want. They can approve purchasers, they can deny purchasers. So, practically speaking, what I hope for from the agents that I work with when the property is an HOA, a condo, or a co-op is to get information from them right from the beginning. What are your rules? What are your regulations? What are you looking for as far as a prospective purchaser? I have one co-op that I've had in my inventory for about 4 years now. Every time we find what we believe to be a qualified buyer, they submit their application and they're turned down. And we really don't know why, because in New York, co-ops actually don't have to give a reason why they're denying a purchaser. So, I appreciate it when the agents come back to me and they say, hey, look, they filled out this questionnaire. This is what they're looking for, all of the qualifications, the things that we don't want to waste our time entertaining an offer from somebody that we know is not going to be approved. So it's really important to get that information right from the beginning and make sure that we're marketing the property to the right purchaser. Things that can I guess create a problem in the REO process. Once we get the asset into inventory, if there's pending litigation in the underlying foreclosure or an appeal pending, it's very difficult to sell the property. If there is litigation still pending, somebody's questioning or trying to contest the foreclosure sale or appealing the judgment, even though it's an REO inventory, it's really important that I feel as an attorney to convey that information to you as the agent, because I don't want you marketing the property right now because we have to resolve this issue. I just recently had a deal come across my desk where the agent, accepted an offer and sent it to me for contract. And I said, wait a minute, we still have an appeal pending. They're never going to get title insurance. Title companies are not going to insure a transaction where there's still litigation pending in the underlying foreclosure. They're not going to insure it where there's an appeal pending. So title companies in general are very skeptical, very hesitant to insure out of foreclosure. They don't like it. They really closely scrutinize the underlying foreclosure. They're looking for any issues, any reasons not to insure. Recently, a lot of my clients, they've been selling properties occupied. That's been a big thing. They don't want to deal with the evictions in New York because they take so long. So they're trying to sell the properties occupied. Title companies don't want to insure properties that are occupied. So, having this information, waiting till all of these issues are resolved, is really important, and it makes it for a more efficient process. Kind of leads me to my next issue is really contract preparation. So I find it essential to make sure that all of the pertinent facts and terms of the deal are conveyed from the beginning. Making sure that all the parties are in agreement on the terms obviously makes for a smoother process. I've had deals where, we're selling a property and we're marketing it occupied and we're selling it occupied. And for some reason, that information is never conveyed to the buyer. So the buyer goes into contract and then goes and looks at the property and says, hey, someone's living there. I wasn't aware of that. Another issue is repairs and violations. Um, from the outset, it should be made clear who's responsible for making repairs. Is the bank going to make a repair? Are they going to, fix the HVAC? Are they going to, upgrade the electrical, or are they selling it as is? Too many times I've had a deal where it's really not conveyed from the beginning, and even though the standard REO contract basically says the property's as is, it's really important. If something's going to be fixed, if something's going to be addressed, it has to be established, it has to be set forth in the contract and made clear to the buyers, so that everybody's on the same page. And I think really important is the property, financeable. So obviously a lot of properties are fixed up and they can be sold and get, conventional financing, and in other deals they're not going to get financing, so should we be marketing this towards an all cash buyer? Should we, say that this is going to have to be an FHA loan? So it's important to, make sure that everybody knows the condition of the property. Are they going to be able to get conventional financing? Do we have to market this towards somebody who's going to pay all cash? Um, that kind of information. It's super important to convey that, make sure it's in the contract, and make sure that all the parties are on the same page, and so there are no issues at closing, and anything that's going to hold the process up. Um, so that's basically all I have. I know I rushed through a lot of information in a short amount of time, so if anybody has any questions about what I just spoke about or anything else, I'm happy to answer.
Yeah, no, thank you for that. We do have a few questions that are populated in the Q&A box. If you can see that, I'm happy to read them off to you as well. And
Sure.
everyone, if you have questions, just click the Q&A box should be at the bottom, and you can submit your questions there. So the first one submitted to Annie from an REOX member. Do you recommend a quiet title action before listing the property?
Well, that kind of depends on what the nature of the issue is. So a quiet title action is really when there's competing ownership interests. I don't believe so. In the context of a foreclosure, at least in New York, I really can't speak to other states, but uh, as it, in the context of New York, quiet title action would probably not be applicable. It's more so if there was a missed interest, like a judgment creditor was not named in the foreclosure, or a former, an owner was not named, obviously more complicated. That's a process called reforeclosure. You don't have to go through the full foreclosure process, but you basically start another action naming those missed interests, and you have to establish why they were missed, and basically giving them a chance to redeem the property or be foreclosed. So a quiet title action is more of one person claims ownership as compared to somebody else claiming ownership, and now you have to quiet title to determine who the true owner of the property is. So it doesn't come up so much in the foreclosure context, but you'd have to do it more so as a reforeclosure. Certainly not applicable to an eviction. I know in eviction actions, all the time I see somebody saying, "Hey, I'm the owner of the property. My interest wasn't, extinguished. I'm still the owner," and the answer that they get in the landlord tenant court is you need to go back to Supreme Court and fight that in the foreclosure action.
That's great. Okay. Next question. How do you recommend we handle as is language in contracts?
Well, as is as is. um, I I would suggest being as specific as possible, and not just saying that that the property is being sold as is. As it's obviously a very general term. My contracts, when I draft them, I take it a step further and I say seller shall not be obligated to make any repairs. Seller shall not be obligated to address any violations or anything like that. So not only do I say that the property is being sold as is, but I specifically state what we're not going to do and what the buyer is going to be responsible for doing. So yeah, saying property is going to be sold as is a little vague, as is physical condition, as is title, as is violations, survey issues. I think to avoid issues down the line, the contract should specifically state that if the seller is going to repair something, it be specifically set forth. Otherwise, the seller should disclaim doing anything and really make it clear it is as is.
Okay, another question. How should we document communication with buyers and tenants to protect the lender and client?
Yeah, that's a great question. Um, Too often, I go into court and I have a tenant say, well, the agent told me this or the agent told me that, and there's no proof of it. Tenants will call me all the time. And what I do is I respond to them and I say, here's my email address. Please put it in an email and I will respond to you. So everything is documented. Obviously, you can't do that all the time. Um, but if you can get something reduced to a text message, those are definitely admissible. Emails, definitely admissible. I guess each state is different, whether or not you can record. Some states have one-party consent, some states have two-party consents. So I don't know if that's always available. Obviously, if you can record a conversation and it is legally permissible, that's great. Do that as well. But emails, text messages, I would certainly endeavor to do, communicate in that manner so it could be introduced into court at a later time if, the need ever comes up.
Yeah, that's great. Laura Dietz had a question. Are you having title issues holding up evictions and foreclosures? California, this is a huge issue right now.
So title issues don't necessarily hold up my evictions. So I do get messages from clients saying, hey, there's a defect in the foreclosure. Should we put the eviction on hold? And it's really dependent upon what the issue is. So sometimes it'll be there was a misjudgment creditor. Well, that doesn't affect my eviction and it doesn't affect my client's title to the property. So in a case like that, I will go back and I'll say, let's proceed with the eviction. At the very least, let's get to judgment. And then we can reassess and see where we are and see if we want to enforce the judgment. It's not, a defect in the underlying foreclosure or a title issue is not a defense to the eviction, at least not here in New York. So I encourage the clients to not waste time and to proceed. Now, if there is a break in the chain of title, if there's something that could potentially affect the title to the property, then I would say maybe hold off until that's resolved. Another issue that comes up is unrecorded deeds. I know in certain jurisdictions it takes a long time for the deed to get recorded. So here in New York, the deed doesn't need to be recorded for you to be deemed the owner of the property. It's the actual physical transfer of the deed from one party to another. Now you're the owner of the property. The purpose of recording it is to put others on notice. That being said, my general suggestion to clients is that we wait for the deed to be recorded because the judges go online and they say, like, who's the owner of the property? And if they don't see the deed recorded, then they might have more questions. Unfortunately, so the biggest problem that I face with I do evictions where other firms have done the foreclosure. And the biggest problem that I face is in New York, we have to pay what's called transfer tax, not applicable in all states, but in New York, you have to pay transfer tax. And in some parts of the state, it could be substantial. It could be tens of thousands of dollars. And foreclosure firms don't want to advance that money. They want to get paid first. And then once they get the money, then they'll record the deed. And it could take 30, 60, 90 days for them to get their money and then have the deed recorded. So I have evictions where I'm sitting with them in my inventory for months because the deed's not getting recorded. And it's just holding me back from starting my eviction. So, the unrecorded deed it's not a title problem per se, but it is definitely an issue which prevents us from, commencing an eviction in a timely manner.
Yeah, that's great. Next question from Richard Wilson. PPE posting and how important are they?
Um, I assume you mean the personal property notice for personal property eviction. So, frequent question I get from clients all the time and agents. And New York doesn't recognize personal property evictions. I know some states do have different eviction proceedings, I believe, for whether you're evicting people or you're evicting property or you're doing both. Okay, New York doesn't have that. So there's no specific rule in New York as to how you can dispose of personal property after an eviction. Each sheriff in a locality has their own rules. So, for instance, after an eviction, some sheriffs require us to just move the property to the curb, and it has to sit there for 24 hours. In other parts of the state, we have to put the property in storage, and it has to remain there for 30 days. So obviously we have situations where we go to the property and there's nobody living there, but there's just personal property. Now, do we want to go through a whole eviction process to just remove some personal property? So I touched on that a little bit earlier, and it really depends on what's in the property. What's the value of the property, personal property that's remaining? Are we certain that the people have vacated? Again, we look at, is the mail piling up? Is the lawn overgrown? The property hasn't been maintained. The utilities have been turned off. Neighbors have said that nobody has been in this property in the past 6 months. Okay, so we checked off the first box that it's pretty clear that they have vacated. So now let's look at what's inside the property. Is it all garbage? I say to the agents, what's the garage sale value? And if they tell me it's under $1,000, then I'll generally say, hey, look, that's your exposure. That's your potential exposure. If somebody comes back, and says, you threw away my stuff, well, we've documented it. We've, took an inventory. This is what was there. And if the worst thing is that we have to give them $1,000 to go away, then so be it. As far as a personal property notice, I always encourage the clients, put a notice on the door for 30 days. Put the agent's information, say, hey, look, this property has been found vacant. We have secured it. In 30 days from this date, we're going to dispose of the property. If you'd like to retrieve your property, please contact me. It's not a legally enforceable procedure, but it mitigates potential exposure. So if they do come back 3 months later and say, hey, you threw away my property, one, we're going to demonstrate that the property was clearly abandoned. Two, that the property that was there was not of really any great value. And three, look, we posted a notice. Clearly, we posted a notice and gave them 30 days. Nobody came to the door. Nobody contacted us. This property was clearly abandoned. And so, and again, I don't know what the legal ramifications are of the personal property notice in other states. In New York, it's more of a method to mitigate potential exposure when we do ultimately dispose of the property.
All right. Next question from Wendy Martin. Oregon is changing its eviction laws and processes in January of 26. Will this change affect evictions and foreclosures already in process or not yet through redemption?
So I can't speak to Oregon laws, but what I will say is, so again, so New York, by way of example, in comparison, New York recently passed what's called the good cause eviction law. And it was not retroactive. So any eviction that had already been commenced was not affected by the good cause eviction law up to the stage that it was at. So, in New York, we now have to provide a notice which states whether or not the property is subject to the good cause eviction law. If it's not subject to it, why? so on and so forth. So the way the statute works is that if we have already served our predicate notices before the enactment of the law, that we don't have to go back and serve new notices. The law didn't require that. However, if we're at the next stage, the filing of a petition with the court, we haven't done that yet, and the law has now been enacted. Now we have to comply. So I would assume that it would probably be, I can't imagine the enactment of a law which would require an owner or a landlord or a petitioner in a landlord-tenant action to have to go back and start all over again because the law has changed. So it would have to specifically state that it has retroactive applicability. I'd be happy to take a look at the statute and read it and report back, but I would assume not. They generally don't do things like that, but I'm not from Oregon, so I couldn't tell you.
Okay, another great question here from Steve Pagano. Some sellers have been marketing properties without being entitled. Can you speak to any liabilities a broker may incur?
I see that a lot. I see that some clients immediately start marketing the property before the deed's even been signed. And the contract, so again, how I draft my REO contract is I put a provision, a disclaimer, which says that the buyer acknowledges that this property has been or is being sorry, I'm blanking on the word, was obtained through foreclosure or deed in lieu of foreclosure. So the buyer acknowledges that the deed may not be recorded yet, and the sale is subject to the seller perfecting their title. So it's a common thing, because of the delays in recording deeds, sellers want to be proactive and get the property marketed, so I have to protect them. So we put language in there that says that it is subject. Everybody acknowledges that the deed may not be recorded, that we have an equitable interest in the property because we were the successful bidder at the foreclosure sale. So I don't think it's improper to proceed with the marketing and sale. We just haven't perfected our title yet. So as long as it's disclosed in the contract and there's a provision that says that the buyer acknowledges that, this is a foreclosure, we may still be waiting for the deed to be recorded, and that the buyer agrees to wait until the deed is recorded so that we can close, and that if for any reason the deed isn't recorded or somebody contests the sale and the deed's not going to be recorded, that the seller has no liability. There's no recourse against the seller. This buyer's sole remedy is to get a return of their down payment, and the terms of the contract are canceled and everybody walks away. There would certainly be no liability to the agent. The only party that would potentially have liability would be the seller. That's why it's really important to carefully craft a contract which protects the seller in those situations.
And it looks like we just have one final question. And if anyone has another question, now's a great time to just get one more in. This one's from Susanna Boyer. Regarding the private property eviction, would you just post the notice on the front door, or do you need to post it anywhere else?
I'm sorry, I didn't hear the first part. Was that for a personal property eviction?
Private property eviction, yes.
Yeah. So again, here in New York, and again, I don't know if there are processes in other states that where there are statutes that govern this procedure, but in New York, we just we don't have to publish in a newspaper or anything like that if that's what you're asking. We just post it on the front door because again, it's more of a question of mitigation, reducing the exposure by the client. So putting it on the front door, I think, is the most effective way to do it. Obviously, if they're coming back to get their property, they're going to see that notice. Just do the stop share. They really want to again mitigate exposure, liability. So yeah, I would say posting it on the front door is probably the most effective way to handle the personal property notice.
Okay. Well, if there are no other questions, Robert, we just want to thank you for taking the time and sharing some hard-earned wisdom and expertise. And to everyone who attended, thank you so much for being a part of this. We will be sending out a recap probably tomorrow about everything that we just spoke about, Robert spoke about. And yeah, once again, thank you for your time, Robert. It's been very informative.
Thank you very much for having me. If anybody has any questions or just wants to, chat, please feel free to reach out to me. I'm always happy to, share my experiences and help you all out.
Oh, Steve Pagano says, how can we best reach you, Robert?
Oh, I will be happy to give my phone number and my email address.
And you can also give it to me as well, and I can put it in the follow-up communication to everyone too.
Yep. I'm not seeing the chat function.
Yeah, for some reason there's as a host not well, actually, oh, there's a type box on the Q&A. You can respond to Stephen there if you can see that.
Oh,
Should be able to type. Yeah.
Q&A. Oh, there we go. Perfect. How do we reach our type answer? There we go. So here's my email address. Did that go through?
Yeah, it's on the answered questions now. It moves it over. So if you see it,
okay.
And we again,
I'm gonna just put in my direct phone number if anybody would ever want to call me. There we go.
All right. No, thank you. That's great. So yeah, if you have more questions, feel free to send those on to Robert, and he will get to them as best he's able to.
Absolutely.
Thank you again to you, Robert, and everyone for joining us. And we'll look forward to doing this again in our next webinar coming up soon.
Thank you. Thank you for having me. I appreciate it.
Thanks, Robert.
All right. Have a great day.
You too.